Well, again, happy Friday. I'm glad we're here. We made it through the week, one step closer to Thanksgiving, time where we get to celebrate with each other and have some good dinner and time with our family away from work. Hopefully, everybody is taking some time away from work when it's off, when you have the time away. But excited about that. Looking forward to that. Again, my name is Isaiah Green. I want to introduce myself as our Assistant Deputy Director and also Central California Regional Advisor here with the Office of the Small Business Advocate that resides within the Governor's Office of Business and Economics. And our goal is to support all 4.2 million small businesses across the state of California with our scaled network success, capital access for leadership and entrepreneurs. And so, again, good afternoon. Welcome everyone to our final session of our 2025 Labor and Employment webinar series brought to you by CalOSBA and also CalChambers. Shout out to the Small Business Policy Council as well. Excited to have you all here. Bianca, it's really the last one. It went by so quickly. It went by so quickly.
Yeah, it has really flown by. I was just going over the list of all the topics that we've covered, Isaiah, together over the last year, and it's a lot of information.
A lot of information.
Yeah.
And with that said, I want to say thank you, Bianca, to you, Cal Chamber, and the Small Business Policy Council for all of the knowledge, all of the insight, the preparation, hours that you've put in, and just the information that you shared throughout this entire series. I want to say on behalf of all of the small business owners in California and also our team at Cal OSBA, thank you, thank you, thank you. Your expertise has been so valuable in this space over the last almost 8, 9 months. So thank you. Absolutely.
Yeah, definitely. It has been a pleasure and an honor. This has been a fantastic partnership that I think we've been able to put together for the benefit of small businesses all across the state, and really hope that those who have attended and go back to listen to the recordings, can gain a lot from it.
And I'm sure they will. I'm sure they will, especially with you at the helm. I'm sure they will. So a few housekeeping notes before we begin, before we get started. This session is being recorded and it will be available on our Cal OSBA webpage and also our YouTube page. And so I know sometimes people ask for the slides post webinar. This will be available. The entire recording will be available for you to go back and rewatch and take notes if you've missed any information. You can also find our previous episodes there on our Cal OSBA website. We will put that information in the chat. A lot of information, like Bianca mentioned, over a couple of different topics over the last 8 months, which we do believe you will find very valuable. Also, we will have time towards the end of this series for a Q&A. Again, if you have questions as Bianca is going through her presentation, feel free to use the Q&A box right then and there just to ask the question. And if she sees it, she'll probably get to it in between slides. If not, we will answer towards the end of the webinar. And so again, feel free to engage and ask all the questions. Today's topic is, we say last, the best for last, but very important topic when we're talking about how best practices for terminating and or offboarding employees, including a number of different topics within that, whether it be discipline, what it looks like for termination, compliance, consideration, and so much more. And so with that, Bianca, I want to pass it over to you. Excited to hear what you have for us today.
Awesome. Well, thank you, Isaiah, and good afternoon, everybody. Happy Friday. It is great for us to all be at the end of the week. Now, before I get into today's presentation, of course, we have to give our standard disclaimer. So just a reminder that nothing in the presentation should be relied upon as legal advice. You may have specific questions or circumstances that we just cannot answer today that you'll want to consult with a qualified attorney on, as nothing in this presentation should be construed as legal advice. Also, just a note, Isaiah mentioned there will be a recording. You'll go back. You'll have the ability to review this. Just keep in mind the contents of the presentation are current as of the date of today's recording. as we know, things do change in California, so we always want to keep that in mind anytime we're reviewing anything back in time, no matter how short or how long. And then lastly, the presentation may not be recorded, duplicated, or distributed, either in whole or in part, without written consent from CalChamber and CalOSBA. So on today's topic of terminating and offboarding employees, as Isaiah mentioned, we do have a lot we're going to talk about. We're going to start off just talking about at-will employment and what does that mean in California and how does that fit into this larger puzzle that we're going to be talking about. Now, we are talking about terminating and offboarding, but we are going to also be touching upon discipline. Common reasons for discipline, those could also lead to, of course, termination, but the types of discipline, which one of those types, the ultimate type, if you will, is indeed termination. But we're going to talk about some of those earlier steps that can happen too, because it's hard to talk about one really without the other, because as we'll see, termination usually, sometimes it can be, but usually is not something that is just an instantaneous need to terminate an employee. It's usually an issue that has built up over time. So we're going to talk about what that process could look like and really what are some of the important things that you need to know. And then, of course, we'll talk about what are some of those final pay and required notices that you have to give for any employee when employment is separating. That's whether they are being terminated or whether they themselves are voluntarily quitting. And then we'll wrap it up, of course, in best practices. All right. So first, let's talk about at-will employment. And so what does that mean? Well, in California, California is known as an at-will state. And so the relationship of the employer and the employee is considered at will. So what exactly does that mean? What that means is an employer can terminate the employee for any reason and at any time, so long as the decision is not unlawful. And conversely, right, an employee can decide that they are going to leave their employment at any time for any reason, right? They're not in a contract situation where they're committed to staying with that employer for a certain amount of time. Now, those types of employment do exist. That's not what we're talking about here today, though. We're talking about anything that's not involving a contract is going to be treated as that at will. And so what that means is, yes, an employer can terminate for any reason at any time. The caveat here, though, and this is why it's bolded, so long as that decision is not unlawful. Okay, and we'll talk about what are some examples of what might make it unlawful. So anytime we're looking at termination, and this is also true for in the realm of discipline as well. Anytime you're taking any kind of negative action or disciplining an employee, including termination, you want to make sure that those decisions are based on objective, legitimate business reasons. So these are things like if there are performance issues, attendance problems, if there's a restructuring or a lack of work, maybe there simply isn't a need for a larger number of employees and maybe you're downsizing. That would be an example of an objective, legitimate business reason. If an employee is unable to meet their job requirements, that would be another example. So what are some of the limits then around at-will employment? And I hear this often, presenting in, seminars and webinars regularly. Attendees often ask about, well, California is an at-will state, but it doesn't really seem like it because, there are all these ways that you can get tripped up and into a lawsuit. And yes, it is true because you can't, again, terminate for a reason that is unlawful. So what are some examples of things that would be considered unlawful employment? Well, if you are terminating based on somebody's protected characteristics, such as their race, their age, gender, disability, religion, we cannot make any employment decision based on somebody's protected class or status, right? So if that's true even in the hiring space. If we're deciding that we're not going to hire, let's say, an otherwise well-qualified candidate because we see that they're pregnant in the interview, that would be, motivated by the protected class, and therefore that would be an unlawful failure to hire. Similarly, if an employee became pregnant and now suddenly they're terminated for that reason, you see how that would be a problem and unlawful. Another example, protected leave. So, and we've in other webinar sessions, we've talked about some of the protected leaves like California Family Rights Act. For those who are larger, I'm not sure how many here today are, but some may be covered by the Family Medical Leave Act. That's the FMLA at the federal level, or pregnancy disability leave. Or lastly, California's mandatory paid sick leave law under the Healthy Workplaces, Healthy Families Act. So those are all protected leaves and absences. And so again, we cannot terminate or discipline for those because that's the whole idea behind it, is that they come with those protections. Similarly, protected activities. That's a real legal term in California, that if somebody is engaged in what is considered a protected activity, so that could be something like reporting what they believe to be discrimination or harassment. If they file a complaint or with their HR department or to their supervisor to say that they are, being, mistreated in some way, that could be a protected activity. Or if somebody's making a complaint, whether it's directly to their employer or maybe to the labor commissioner's office, that they're not being paid their wages appropriately under the law. And for those of you who attended our wage and hour, sessions, things like meal and rest breaks and all rules around proper classification, they come with a lot of rules, right? So if an employee is reporting what they believe to be a violation around that, or they're making even safety concerns or whistleblowing to an outside agency, those are all protected activities that then if an employer, as a result of them going and taking those actions, is now terminating the employment or engaging in some adverse employment action against the employee, that is going to be unlawful. And then lastly, if an employee, again, is refusing to break the law, that would be another example, right? They're upholding public policy, and if they're terminated for that, that would also be unlawful. So these are just some examples of how you could run afoul of, yes, we have at-will employment in California, but we have to always make sure that we're not terminating for an unlawful reason, of course. All right, so before we get into things like performance and discipline and all of that, of course, and employee handbooks has really been sort of a central theme throughout many of our sessions together. And so again, this is really just a reminder. Yes, it's true that employee handbooks are not legally required. However, they are indeed considered a best practice. So there are a lot of reasons to have a handbook. It's a central place where, even if you don't have a handbook, first of all, there are certain policies that in California we are required to have just as employers, and you have to distribute those, whether it's in the single handbook or whether they're separate. So having a singular place where you can distribute all of your policies is just a convenient tool. And it's also a great place to have other policies that are going to set the expectations when it comes to things like conduct and behavior. Again, in order for us to, what we're talking about when we're talking about discipline and termination, essentially, is we're talking about accountability, right? So in order for there to be accountability, we have to set that bar, and we have to make it clear to our employees as far as what is going to be required of them, what are the expectations, and just as important, oftentimes, not only what is expected of them, but what are the things that are unacceptable when it comes to conduct and behavior. So another benefit to having the handbook with all of these policies is that it's going to promote consistency and fairness in their application. It's going to be a tool for our managers to use. We want to make sure too that our managers are trained and that they know that they need to enforce them consistently, right? If we have managers who are not applying the policies consistently to their staff, then that can be problematic, as we may have employees who now are claiming that they're being treated differently for maybe a discriminatory reason. So handbooks are a really great tool. We want to make sure, of course, we always have that acknowledgement page where they are indeed signing off on the fact that they've received the handbook, they've had an opportunity to review it, ask any questions if they have them, so that can be, again, they can be reminded of that if we're having to have a discussion with them later on about, reminding them, you signed this, you understand that these are our policies, this is the conduct that we don't expect, all of the things around expectation and behavior. So another note, this isn't really specific to handbook and policies. Before we move on, though, one thing that I do want to just a quick note, in case any of you are familiar with this idea of like a 90-day introductory period, because of course the handbook is something we give to employees, upon hire. And what about this notion that within in the first 90 days of employment that we sort of have this more relaxed, or this ability to sort of get rid of an employee if they're a problem within that first 90 days. And this kind of touches on what we talked about with the at-will employment. And so I just want to mention that an introductory period, it's great if you have an introductory period and maybe you talk about that in your handbook. But the thing to keep in mind is that somebody being in the first 90 days of their employment isn't going to protect you as an employer for any legal claims. You're still going to need to be looking at, if you're terminating within that first 90 days, just as you would beyond the 90 days, right? Is there a legitimate business reason for this decision to end the employment or otherwise discipline? So that's going to apply. So I just like mentioning that because sometimes people may have an understanding that within the 90 days, it's sort of just free game, that, we can get rid of somebody without having to be worried about liability. And again, that's just not true, right? You're still subject to the same caveats that we talked about around at-will employment and not terminating somebody for a reason that is unlawful. All right, so performance evaluations. Again, because the fact we're not jumping to termination right away, because a lot of times termination will stem from performance issues. That's one of them. And same thing with discipline. And so it goes again to the idea that we talked about we have to first set that bar, right? A handbook is one way that we can do that. That's not the only way, of course. It's just like I said, a piece to the bigger puzzle. But this is really a great tool for assessing performance and setting those clear expectations. So, first and foremost, you can ask yourself, do you conduct performance evaluations on a regular basis? If you don't, maybe take a look at that. Or are you doing it, frequently enough? So it's a great opportunity to provide that candid feedback to the employees. Of course, recognizing them for their strengths, but also identifying areas for improvement and growth. So again, they are aware of the areas that they are expected to work on. So they can be, again, used as a way to outline strategies and goals for that next review period. It can help for the employee to be working towards something. You can build things like goals into performance evaluations. So again, they're really a great tool. And within that, that early period, you could certainly consider having one like in the first 30 days to 90 days of employment, right? Getting that feedback early on is great to address anything if there are issues in the beginning, so they're not perceived by the employee to just viewed as this is acceptable. And then a year into at the year evaluation, they're being told for the first time, well, you're doing XYZ and this is a problem, right? We need to let them know early into the process. And so having that built-in 30 to 90 day evaluation is going to help with that. And by no means would it mean that you need to wait 30 days either, right? If there's something on day 1, day 2 that happens, we have a discussion with them, again, setting the expectations, making it clear. But at a minimum, you should be looking at doing performance evaluations at least annually. Some organizations do it more. Again, it's going to depend on your needs and what's appropriate for your business. But if you're not conducting them at all, I encourage people to take a closer look at that, as they can be very helpful, especially when it comes to needing to discipline for performance specifically. All right, so another component that we look to around the topic of discipline and termination is workplace culture, right? What is the culture of the workplace? This is going to set the tone for things like discipline, productivity, and morale. So we can also look at this as an opportunity for, mentoring, coaching, these and having fair discipline. All of this is going to strengthen employee performance, hopefully have an open dialogue between supervisors and their staff. And so we want to, again, be thinking about what is the tone in our workplace when it comes to things like this. So looking at how are the managers perceived, by other staff? How are they using their authority? Of course, one of the reasons that supervisors have to take a harassment prevention training course that's twice as long as employees is because there's a whole section that focuses on that power disparity that exists between supervisors and employees. So it's an important thing that we want to make sure that our managers are aware of. Whether HR has a clear and active role. You may or may not have a dedicated HR department, depending on, the size of your business. But if it's not officially called HR, who is the person who's in that role, and what is their involvement when it comes to issues around performance or conduct? We want to make sure, of course, that the consequences for policy violations are applied consistently at all levels. Again, going back to not just having the policies in place by way of an employee handbook, but how are we actually addressing the issues when they arise? And then, again, looking at whether your performance evaluations are conducted regularly and taken seriously. That's the other thing that I should have mentioned when talking about performance evaluations. Performance evaluations are only going to be as helpful as they are honest. So oftentimes what I have seen is that managers will give employees flying colors on their evaluations, even if there are certain things that maybe are problematic, but they're not being specific in those evaluations, or at least they're getting a meeting expectation. So there isn't that real communication, again, of setting the expectations for that employee. And then later that manager, after so much time, will want to present that as a reason for terminating, claiming that this has been an ongoing issue. But then when we go back and look at it in the performance evaluation history, it's never addressed. So those are, again, performance evaluations can be a great tool, but they have to be done regularly and they have to be done honestly. And so we have to train our managers around, evaluating performance as well. All right. So now let's talk about some of the common reasons for discipline and termination. Not necessarily exhaustive, but sort of just bigger chunks that we're going to break it into for purposes of today and our limited time together. We've got work performance issues. We've got conduct and behavioral issues, dishonesty and related problems, and attendance issues. So let's start with the work performance issues. So this is usually, you've got an employee, they're making frequent errors, but that doesn't necessarily mean they're not trying, right? So maybe the effort is there, but they may be struggling to meet expectations around performance. So some examples of this could be that they're not completing the work assignments or their duties. Maybe they're turning in their work late, or they're completing tasks late. If they have poor quality of work, so maybe they are turning their work in on time, but what they're turning in is not meeting the expectation, or if they're providing a poor quality of service, if you're like in the restaurant or service industry and they're not, engaging with the customers in a way that is expected, those are just some examples of what would fall into the category of a work performance issue. Then we have conduct and behavioral issues. So these are things like, insubordination, whether they're outwardly refusing to do something, or if it's just a repeated failure to, again, follow a policy. Maybe they're expected to wear certain safety gear when engaged in certain tasks, and they regularly are not, right? That could be an example of insubordination. If they're engaging in any kind of harassing, discriminatory, or retaliatory conduct toward other employees, horseplay or fighting, violence or threats of violence, that's obviously a very serious one. We have failure to use safety devices. That kind of ties into the example that I gave of insubordination. And of course, we have things like if you're intoxicated at work, or a possession of drugs or alcohol in the workplace. And again, the idea is you've got policies addressing these types of things, right? We have a code of conduct policy that we would be able to remind our employees of these. But so it's not as if they don't know coming into it, what do we expect of them and what do we not expect of them? So any other type of company policy, again, whatever it may be, that's where the handbook is going to be your friend, because you're laying it out all for them, and it's not a mystery that they're just supposed, we're not holding them to a standard that we didn't communicate, basically. All right, so then we have dishonesty and related problems. So this can be things like theft. If you discover, for example, that somebody falsified an employment application, somebody willfully damages company property or their coworkers' property. Another one that sometimes happens is the falsification of time records. So it could be their, padding their own personal time card, or maybe they're doing it for another employee. Or falsifying business records. Again, not an exhaustive list. These are just some examples. With some of these, these can be considered more egregious, things like, theft, or, falsification of time records. Those may be things that may warrant an immediate termination. So and we're not talking about progressive discipline here today, but one thing I like to note is that if anybody does have sort of a progressive discipline policy where you sort of lay it out where it's like, first it's, a verbal warning to a written warning to a final warning to then it's termination, right? Having that stair-step progression. It may work sometimes, but if you do have that policy, you want to keep flexibility in it, because sometimes you might have conduct that it only takes one time and that employee can no longer be employed with you. So do keep that in mind if you have any sort of a progressive discipline policy. All right, and then attendance issues. So this can be a common one, and it can also be very tricky. So attendance can be around, if there are just unexcused absences, chronic absenteeism, or if we have excessive tardiness, or somebody's leaving without permission. So there could be a whole host of issues around attendance, but they are tricky. And what makes the attendance issues tricky is that we have to remember, like we talked about, that there are certain absences that are protected. And that means that they cannot be penalized for under your attendance policy if they are missing time under, let's say, because they're using their California mandatory paid sick leave, their CFRA or FMLA leave, their California pregnancy disability leave, or any other type of leave. There's a whole host of other state leaves that we touched on previously to where this would apply. So if you have an attendance policy where you issue out occurrences for unexcused absences, let's say, or absences in general, whether they're excused or not, if you're still penalizing an employee in any way for those absences, your policy needs to specify, and the practice needs to be, you're not talking about those certain protected absences, because again, we cannot penalize our employees for those. So attendance, again, it can be tricky because a lot of times if an employee has a disability, maybe they have a need for intermittent leave under CFRA, it can be disruptive. It can feel disruptive from the employer side, but again, we have to remember there are protections around it. So we cannot necessarily discipline for them for that, unless then we go outside of the realm of what is protected. So that's, kind of what I touched on here is reiterated on this next slide about, again, you need to be careful about applying the policies fairly and consistency, keeping in mind that we have those certain protections. Another thing that this first bullet is getting at with this no fault attendance policies, those can be tricky. So you want to be careful about no fault attendance policies. They can open an employer up to liability. And so what I'm referring to with that is, a typical no call, no show, where an employee may, if they don't show up to work, 3 days in a row and they have not called in, that immediately converts to a termination. You still want to make sure that you're reaching out to that employee and finding out what's going on, making sure there isn't something that they're not hospitalized or there isn't something extreme that's happening that's preventing them from coming to work. But as I mentioned, outside of the protected leave, then yes, your policy will determine at what point are we considering these absences excessive such that we can discipline around it. But remember, this is where training our managers, making sure that we're applying this consistently within the organization is important, because if we have a manager, let's say, where they're letting one employee come in late regularly, they're absent frequently, and they have another employee that is not engaged in that as frequently, but then the few times that they are, they're actually being approached about it or reprimanded in any way, you could see how that would create a problem. And could open an employer up to a discrimination claim, because now you have maybe two similarly situated employees. Maybe the only thing that's different between them is what protected categories they fall under. And so we want to make sure that we're always consistent in how we're enforcing our policies. All right. So now let's talk about the types of discipline. And before we get into the types of discipline, one other thing I just want to note is that in California law, we do have this 90-day presumption rule that comes into play. So anytime there's an adverse action taken against an employee within 90 days of a protected activity, and we talked about, examples of protected activities earlier, it's presumed, so that adverse action, whether it's a discipline that constitutes an adverse action or a termination, it is presumed that the employer is being retaliatory about that. If it falls within the 90 days. Now, that said, that doesn't mean that if an employee has complained to you within the last 90 days about something, that you can't discipline them or subject them to an adverse employment action. I just say that to reiterate the importance of, we need to have legitimate business reasons for what we're doing, because we need to be able to show that, no, we're not retaliating against the employee who complained, and that's not why we fired them or disciplined them, but because we have legitimate business reasons for doing so. So the first thing that we'll talk about is a disciplinary warning, or this is also referred to as a corrective action. Now, this can be, verbal or, oral face-to-face, just a discussion, or it can be written. So this is usually going to be like the first, kind of issue that is addressed, right, with the employee, that it's if we consider it a warning or a corrective action. So we want to, again, address this early on to correct any sort of misconduct or poor performance issues. If we're seeing something early, then we need to say something so that we can make sure that it gets addressed. So again, this is where a handbook and having policies is going to be important to look at to determine, okay, what is the, to verify, is this underlying conduct a violation of our policy? And sometimes what might happen is, depending on the strength of your policies and how detailed they are, you may run into an issue that is not yet existent in your policy. And so you may not be able to hold an employee accountable the way that that you would necessarily want to, right? If you're looking at being fair about it, if they didn't know, for example. So that's where we want to make sure, again, that we're communicating what are the expectations. And then confirming, okay, this is a violation, and then we discuss the violations with the employee. And the last piece I'll add to that is, if something comes to your attention that is indeed not addressed in your handbook, then of course, this is where handbook revisions are great, because then we can add in information. If things that maybe previously were not an issue, and we learn they're an issue now, where suddenly there's a trend of employees engaging in XYZ, okay, we need to address that in our handbook. So you can always update your policies to address what's happening in the workplace in real time. Okay, so next, so part of the disciplinary warning, it can also be, as I mentioned, it can be verbal or written. So the written disciplinary warning is going to be, it's a little bit more formal. So if you're at that point where you're having that formal written warning, there is certain information that you should have. It's all listed for you here. I'm not going to read through all of it, but really what it's getting at is, as a colleague of mine has likes to describe, it's the who, what, when, where, and why of what is going on here. And so we look at that. And the other thing, when you're writing out the disciplinary warning, is the key is that you're being fact specific, right? And so anytime that we're engaging in any kind of discipline, we want to make sure that we're fact specific about what the issue is. So we're not using vague language like, having a bad attitude, or, not good with customers, right? Well, what does that mean, and who gets to define that? So instead of, not good with customers, maybe we're being specific about the fact that a customer, or this employee has received multiple customer complaints over X period of time, where the expectation is something else that we are able to specify. So again, as much as you can tie it to objective information, and then detail all of that, information. This is also the place where one of the things listed here is, if there have been prior corrective actions or warnings. So if this is the first written warning about it, you can capture the fact that, employee was spoken to, X number of times on this date, this date, this date, and informed that they were expected to improve, all of that. And then in this warning, we also have to include, right, what are the consequences if the behavior is not changed? And what is a follow-up date if applies? We expect that this, that as of this date, this will no longer be an issue, or, again, however we need to lay it out specific to our circumstances. Getting the employee's signature is also really important so that they can acknowledge that they understand the warning. We can also include a section for the employee to respond if they feel like they want to document something, their own accounting of the situation. Sometimes, a lot of times we get questions, what if the employee refuses to sign it? Sometimes they will, and you can simply note their refusal to sign and move on, but it doesn't change the fact that they were spoken to about it, and that all of this was explained to them. And then, of course, you would, this could go into their personnel file as well. All right. So next is a performance improvement plan. I put in a slide here, but I don't want to get to, again, this is performance improvement plans. Again, they're a great tool when we need to coach around performance. This isn't so much around behavioral issues, but it's really when we are trying to help somebody to get their performance up to where, right? Again, if somebody is engaging in egregious conduct, we're probably, that may be something where they're going to be terminated. So it's really more suited for performance issues. The thing about performance improvement plans, it's like performance evaluations, is they're great tools if you do them correctly. So I would just encourage you to, if it's something you're looking at, again, doing more research on them, getting clear on, what they should, the information they have, because you want to have clear expectations outlined. right? What do they need to improve on? What are those expectations? How is this improvement going to be measured? They should always include a statement that failure to meet the expectations may result in further discipline. And this is the key part, up to and including termination, right? So again, if you have somebody who's in charge in HR, then it should be an exercise that's done with the supervisor, the employee, and HR to go over, again, all of those details. And then, of course, documenting the meeting outcomes and decisions in writing. And so as we're talking about the different disciplinary measures, of course, documentation is key around all of this. Even if it's just a verbal warning that you're giving to an employee, you still want to have that encourage your supervisors, or if you're the supervisor, you want to have that documented still, right? So again, we have a record so that if we have to escalate things, we have the documentation to back that up. So the disciplinary meeting, it is another form of discipline, but this is really going to go hand in hand again with the written documented warning, or that PIP that we're talking about. And so we should have these meetings, conducted in private. Of course, it's not something we want to address, disciplinary issues in front of other coworkers of the employee. You could consider having a witness, depending on the circumstances. And again, the purpose of that meeting is to discuss that warning that's being issued, or that performance improvement plan, right? You're identifying the specific performance or the conduct at issue, and then identifying the goals and plan for solving the issue, scheduling any follow-up meetings, and really do try to look at it as, ending the meeting on a constructive note if possible, particularly around performance issues. I know sometimes that it's, can be uncomfortable for those of us who have supervised employees and having those difficult conversations, but then also like recognizing them for where are they doing well, and how can we keep things on a positive path and encourage them, right? So, we don't want to always look at discipline as just sort of we're there to just get people in trouble, and we're trying to set the stage for them to ultimately, we're not trying to set people up for failure. That's not how we should be looking at it. We want to give people the tools to succeed. And so, ending on a constructive note, of course, if you can. And at the same time, though, it is going to help us if things do not progress in the way that we hope them to. So, of course, getting the signature on, those written warnings, as I talked about. If they refuse, which they might, you just simply note the refusal and move on. You can have, this is where if you have a witness present, then, they can sign to confirm the refusal of the employee. All right, so now let's talk about termination, which again is can be done at any time, right? As we talked about with at-will employment, as long as the termination reason is not an unlawful one. So as I mentioned, termination, it is another form of discipline. It's pretty much the ultimate form of discipline, because then they will, once terminated, they're not your employee anymore. So every termination, as any adverse employment action, such as a demotion or any kind of discipline that you're really engaging in at that deeper level that's impacting their employment, needs to have a legitimate business reason. So I talked about this before, right? We don't want to have these vague reasons for termination, such as, oh, it's just not a good fit. Or, well, I don't have to give you a reason because it's at will employment. And it's true, you don't have to provide a reason, but the downside is if you don't say anything and you're leaving the employee to guess, then the employee gets to go and create their own narrative and potentially file a claim at the civil rights department, or, or bring a lawsuit. And again, right, depending on what their work history has been, right? What's been happening to lead up to the termination. A termination, that's done well, it should not be a surprise to the employee, especially when we're talking about performance issues, right? Where they're just not able to perform the job. And we've given them opportunities to. It should not be a surprise to them when we sit them down and have that conversation. So again, this is where you should have sufficient documentation to support the reason for the termination. When going through looking at terminating somebody, of course, for an employer to evaluate those potential wrongful termination risks is going to be important, right? Do they belong to a protected class? Have they recently engaged in a protected activity that is going to put us into that 90-day presumption of retaliation? These are the things that need to be looked at, but ultimately should be consulting with legal counsel if you have concerns about those, to make sure that it doesn't mean you can't terminate. Again, if you had that legitimate business reason, but you're going into it eyes wide open and you know what is going to be at stake. And then lastly, the thing around timing, I apologize for the sun here, is you want to confirm when payroll will have the ability to issue that final paycheck, because we'll talk about the timing around final pay, and it is important. It is technical. We want to make sure we have the ability to provide that check at that very moment that we're ready to terminate somebody. Now, sometimes it may be the case that, again, I was talking about a termination situation that's really based on performance, where maybe there have been issues, we've let them know, no improvement. Okay, now we have to terminate. Sometimes an employee, again, maybe if we're talking about workplace violence or something where they need to be terminated immediately, and payroll may or may not be available. Sometimes we have to do what we have to do, and we can talk about what that might look like when we get to the final pay. But in a perfect world, again, if you're scheduling and you're deciding when is this termination going to occur, you absolutely want to make sure you're communicating with your payroll to make sure that you're going to have that final paycheck issue, because as we'll talk about in a moment, the timing is critical. So just like when we talked about with the disciplinary meetings, termination meetings are also very similar, right? So you do, again, want to provide a reason for the termination. It's not a time to engage in any kind of a debate with them, right? Again, by the time that if it's particularly in the performance situations, or if it's a chronic, absenteeism issue or tardiness that, again, is not protected in any way, and they've been warned time and time again, if it's something of that nature, by the time they're being sat down to be told that, this is what's happening, it really shouldn't be a surprise. So, and again, that's not the time to go into a debate and rehash everything with them, because likely if we're here at this point, we would have had multiple discussions with them. We have all those things documented. So we don't need to go down that road. Now we can, again, remind them of what those prior disciplinary actions were. Now, again, unless it's something so egregious where they're terminated on the spot, we can certainly remind them of those things. And depending on the situation and, how contentious things may be between the employee, and management and all of that, you could consider, involving security if there are any kind of safety concerns, have some of those logistical things figured out. If it's an office setting, to where they have their belongings, how are you going to, do we have concerns about giving them time to get their things? We can certainly offer to have everything, shipped to them, just be thinking about, the time of day. Are we going to do it in the middle of the day when everybody else is around? These are also some of the termination considerations that you go in when you look at the timing. And as I mentioned, because you want to make sure you've got that final paycheck and the required notices that we're going to talk about. Having the employee acknowledge receipt of the final check is also going to be really important, because again, that's going to prevent them from claiming to the labor commissioner that, they did not receive their final pay immediately upon termination. This is also where having a witness could be beneficial. So these are all of the things you need to think about. Again, depending on the circumstances and depending on the termination reason and all of that, there may be some circumstances that aren't going to be this blown, out of proportion, but there may be some that have to be escalated, again, where you do have security, involved, if there are safety concerns. It's really going to depend on your particular circumstances. All right. So as I talked about, final pay and required notices. So this is something that we have to make sure when we are separating employment of any employee that they're paid on time. And so timing of final pay, there are different rules depending on, are we talking about a termination situation where the employee is, we are deciding as the employer to separate that employment, or if the employee is deciding that they are quitting employment. So the first scenario where it's the employer that is terminating the employee, final pay is due immediately. That means we need to have that final paycheck in hand when terminating. If you have employees who have accrued vacation, or if you have a single PTO plan that also includes sick time, all of that has to be paid out. That is included in their wages. So we have to make sure that we're including that as well. If you have an employee who quits, then the answer is a little bit different depending on the timing. So for an employee who quits with more than 72 hours notice, so that's usually, your standard 2 weeks notice in many industries. In that situation, we know that the final pay is going to be due on that employee's last day of work. So they've given us 2 weeks notice. Let's say we know when that date is. On that very last day of work, we need to have their final pay in a check ready for them. If the employee quits with less than 72 hours notice, sometimes this happens, right? Employees may be fed up or something happens drastically and they just decide, that's it, I'm out of here. I quit. In that situation, then we have to make available at the employee's workplace, the paycheck available within 72 hours notice of whenever they quit without notice. Okay, so less than 72 hours gives you 72 hours to provide that. Now that's true even if it's like a Friday afternoon, right? We're talking about clock hours here. So there's no pause for the weekends or holidays or anything like that. So we have to keep that in mind. Now, in that scenario where an employee quits with less than 72 hours notice, they may also request that final pay be mailed, but they need to be the one that makes that request. Okay, we never want to be mailing the final pay to them on our own, because our obligation as the employer is we need to make it need to make it available at the employee's place of employment within that 72-hour period. Then it's on them to come and pick up that paycheck. If they do request that the final pay is mailed, then also best practice for you to get that confirmation in writing from them, get written confirmation of the address of where they are going to have it mailed, right? So you then can make sure that you have that trail, that paper trail of showing that you've met your obligations. All right, and then a note about avoiding unlawful deductions. So one thing that we want to make sure we stay away from is deducting from final pay for things like unreturned property. This could be like tools, uniform, equipment. The exception to this is theft or gross negligence. And again, so you want to be careful about relying on that as a basis to deduct. So the general rule is it's just we can't. And even if the employee has signed something that is allowing us to, it still doesn't make it lawful. So keep that in mind, because some employees might not know, right? And so we can't make those deductions. Similarly, we cannot deduct for employee debts. If we've given employee a loan and now they have quit on us, we can't just take the balance of that loan out from their final pay, nor can we, take out anything for sign-on bonuses, training costs, any other kind of compensation that was already paid previously to them. We cannot take any of that out from a final paycheck. So as a reminder, the only things that we can deduct from an employee's paycheck are taxes, court-ordered garnishments, or deductions that are required by a legally compliant commissions plan. So if it's not one of those, and then we're not pulling them out. All right, now for the notices. So we do also have some information that we have to provide to our employees. So the notice to employee as to change in relationship, that's going, again, indicating that, you know, whether it was voluntary or involuntary, we need to provide that form to them with information on that. And then we have the unemployment insurance pamphlet. That's the For Your Benefit, the Form 2320 through EVD. We provide them that. And then if you have COBRA or CalCOBRA notices, so, you know, COBRAs for those with 20 or more, CalCOBRAs, if you're the 2 to 19 employees, is the threshold. You know, if either of those apply, we need to provide those appropriate notices. And then we also have the health insurance premium payment notice, or the HIP notice. And that program provides an optional premium reimbursement program under Medi-Cal. So we need to make sure that we get that information out. We often get the question about, can we issue this electronically? There is, unfortunately, no express authority or authorization for employers to provide these notices electronically. So you will want to provide that by paper. One other thing, just going back quickly to the timing of final pay that I forgot to mention. The timing of final pay is important because if you do not pay the employee on time, then you will begin to incur what is referred to as waiting time penalties. So if an employee is not paid on time, then the penalty for that is equal to the employee's daily rate of pay for each day that the wages remain unpaid. And that can go up to 30 days. So it could get, you know, a little costly if you are, you know, dragging your feet on paying somebody for any reason. And so you want to make sure, again, that's where the coordination is going to come into play. I see Jennifer has a question about, can the final pay be given online? So for example, through direct deposit. And so here's the deal with direct deposit. So the law does allow for direct deposit of final pay if an employee has an authorization in place for it. But here's the tricky piece, is that we still have that due immediately upon termination component. And so it's not enough that you initiated the direct deposit as of their termination, right? We have to make sure that that money is in their account. And as we know, at direct deposit, and banks can be finicky and things happen, we don't always have control of when those funds are going to actually hit their account. So we just need to be mindful of that and keep that in mind if we are using direct deposit. Another thing is that even though this law did change, the Labor Commissioner, and that's the agency that enforces this, on their website, they still have language that says that it's not unless you get a separate authorization for it. And so we just like to call that out for folks too. So it's just something to be aware, but really it comes down to it's a practical timing issue that, again, you want to make sure that it's hitting their account immediately. All right, so I know we are close to time here, so we will just wrap it up with some best practices. I know we talked about a lot. Again, the world of discipline and termination is very vast, and we could have a whole day just talking about this topic. So, you know, just some reminders of the things that we touched upon. Having those expectations laid out for your employees out the gate is going to be really important. That's going to be able to lay that foundation for you to address performance issues, conduct issues as they arise. Again, making sure that we're applying the discipline consistently across all employees so that we don't have claims of unfair or discriminatory treatment. Documentation is key, as we talked about. So documenting the dates, facts, witnesses, any prior coaching efforts when we're disciplining employees. And like I talked about, really using that fact-specific language, right? And making sure our managers are trained on how to document those facts clearly. So, you know, avoiding that vague language like bad attitude or, isn't good with customers. Let's expand on that. What does that mean? Why is it problematic on how they were engaging with the customer, and how did that deviate from the expectation that has been set? And anytime you're disciplining or terminating, having that decision-making process documented, again, just so that we can address any potential claims. And then, of course, we talked about the final pay requirements, again, depending on whether we are the ones that are separating, making that decision to terminate the employee, or the employee is going to quit. Again, we have specific timing rules around that. We want to make sure that we're always meeting those final pay requirements to avoid those waiting time penalties. And then, of course, when in doubt, consult legal counsel. Sometimes termination decisions can be cut and dry, and sometimes they are anything but. And given the circumstances, given the history of complaints and performance issues and things like that, you can find yourself in a situation where what the path out needs to be, but it doesn't maybe appear as clear-cut as how to get there, or you recognize that there's liability risk, and so getting legal counsel involved in how you can handle that is really going to be your best bet in terms of doing your best to address all of those potential issues. All right, well, I think I have covered everything, so I'm happy to take any questions if we have any.
Yeah, excellent job. We do have one question that was thrown in the chat. Jennifer asked if an employee fails to return some sort of device, an issue device like a cell phone or laptop, printer, etc., what recourse do they have to take in that position?
Yeah, it's a great question. So I'm going to start off by telling you what recourse you don't have, which I'm sure you know this, and I just covered it, but I want to reiterate is what we aren't going to do is like take it out of any kind of final pay, right? So yes, what is the recourse that you have? Communicate with them, right? Let them know that you need it returned. Make it as easy as possible for them, right? Like you can send them a package that has the prepaid shipping on it, and all you're asking them to do is put it in there for you and send it back. Ultimately, if they're not, then really what you're looking at is, depending on the value of the property, is like a small claims issue. But it's all of that's handled right outside of any obligations or the relationship between the two of you as employer-employee. So if you can try to figure those pieces out too at the time of termination. Again, if you are terminated, let's say they work remotely, right? You can send all of that as part of the package. Here's the box. All we need you to do is put this equipment in and leave it at your doorstep, and it's going to be picked up.
Awesome. Awesome. Thank you for that. Any more questions in the chat? Any more questions that you may have on the top of your mind? We have one. I'm going to answer just for sake of time. We're over time just by a little bit. Cindy asked a question. The COBRA forms, can we mail them, or do they have to be handed to employees? Yeah,
so they should be provided again at the time of termination. Like I said, there isn't any explicit authorization for us to provide it electronically. So paper is going to be the way to go. If they're being terminated in person, then that should be something part of their pay, that should be with their paycheck and everything else that's being handed to them. If it is a remote termination that you're doing where you're already having to mail all the things, then yeah, you would just be mailing it.
Awesome. Got some engagement here. I do see one more. I do see a few questions. If you're okay answering, Bianca, what's the difference between a doctor's note for accommodation and FMLA?
Oh, good question. Okay, so this is a little outside of discipline termination. That's fine because I'm happy to hang out with you all because it's our last one. I'm a little sad. But okay, so doctor's note for accommodation can be something. An accommodation is not necessarily time off from work. It can include time off from work, but it isn't necessarily. So an accommodation could be something that involves, let's say, needing additional equipment or needing the ability to sit or stand when you wouldn't otherwise, or something. It can be a whole range of things, right? So whether or not somebody's eligible yet for like CFRA or FMLA leave, accommodation is something that's always going to be available. There's no minimum amount of time, for example, that they have to work for you in order to be eligible for an accommodation. In order to qualify for like CFRA leave or FMLA, there are specific requirements in terms of how long they worked for you, how many hours they worked for you in the last year. FMLA has a quirky third one that has to do with the employee count within a 75-mile radius. So they are different, but somebody where they could overlap is if you have an employee who, let's say, they have a need for an accommodation, let's say where they have to work intermittently. But if they're also eligible for FMLA, then we could track that as like FMLA time to where it would be deducted from their total bank. But if you have somebody who, let's say, they need to work intermittently, like they need to be absent intermittently and they're not yet eligible, then that could still just be an accommodation, even though they're not yet eligible for FMLA or CFRA.
Awesome. Thank you for that. Hopefully that answered the question. I'm going to propose one more question, and we'll wrap it up from here. I think this is a good one to end on. Bianca, could you provide an example of a termination explanation for an employee who just is not a good fit?
Oh, I love this question. So I think I think I would challenge you to actually look back at, well, why is this employee not a good fit, right? And because we need to make sure that the reason that we need to terminate them is for a legitimate business reason, and that we if asked, or if the termination decision was challenged, would be able to demonstrate that this was a legitimate business reason. So what that means is, have you had issues with this employee that have been addressed, that the employee is not improving? How many times, right? These are all of the things that we've been talking about, that you want to make sure that we're staying away from that vague language. And it may be that truly that employee, that there are issues that warrant termination, but we need to look at it and to be able to say, okay, what are those objective, fact-specific reasons? Are they not turning in their work in time? Are they, not coming to work on time? And remember, attendance issues we have to explore to make sure there aren't any protections around those attendance problems. So, and I get it. Sometimes an employee may come in and it doesn't feel like they are vibing with the rest of the work crew and everything, and that might be tricky, but we still have to have a real reason, right? And the reality is that if it really is just like they're not a good fit with our work culture, and and they're not enjoying it, we're not enjoying them, at some point that may naturally solve itself. But we want to make sure that if we are making a decision, again, what is the legitimate business reason? So, and if you don't have one, you don't have that documentation, then what can we communicate to the employee to set those expectations for them? This is what we do expect of you. And then we see, right, are they meeting those expectations? And then if they're not, then we document and we can proceed accordingly.
Awesome. Thank you for that, Bianca. So for the sake of time, we're about 10 minutes over, rightfully so, because of all of the rich information that you were able to provide. Our attendee says thank you for answering that. And I want to just kind of circle back. I want to thank all of our attendees that showed up today and offered their time. We do hope that this information was very fruitful for you. And if you want to go back and look at this information and consume this information again, please visit our website at calosba.ca.gov. All of our webinar series will be on that page. So not just today, but if you've missed any of our topics in the past, you will have the opportunity to view them. And we know that they will be fruitful and very, very important for the work that you do here in California. And so again, Bianca, thank you for all of your insight, your expertise, and the time that you have given here, not only to us as a partner as CalOSBA, but all of the small businesses across California. To you, CalChamber, Small Business Policy Council, we want to say thank you.
Oh, thank you. It's been a pleasure working with you, Isaiah. And like I said, I hope everybody enjoyed it. And thanks for joining us today. And yeah, take care, everyone.
Awesome. Have a great weekend, everyone.